Translation, your rights depend on your zip code. We talk a lot about convictions and how they mess with your life. Jobs, housing, licenses, the basics you need to build something real. States like New York and Washington give preference to local folks when handing out cannabis license. Makes sense, right? That's the whole point of MARTA. Help New Yorkers hurt by the war on drugs finally get a piece of that pie. But out-of-state companies have been pissed, and they've been suing. They say there's a constitutional rule, the Dormant Commerce Clause, that bars states from playing favorites with businesses just because they're out of town. Weed is still federally illegal, classified as Schedule I substance under the Controlled Substance Act. So in January, the Ninth Circuit Court of Appeals ruled that the DCC, constitutional doctrine that prevents states from discriminating against interstate commerce, does not apply to state legal cannabis markets. Because Congress has deemed the market illegal at the federal level, states cannot be said to be interfering with a legitimate interstate market that the federal government says shouldn't exist in the first place. So court in California just says states can play favorites with local cannabis businesses because technically that's not supposed to be an interstate weed market to discriminate against. You can't complain about being left out of something the government says isn't supposed to be happening at all. Two other federal appeals courts, the First Circuit in Boston, that's Maine, Massachusetts, New Hampshire, Rhode Island, and somehow Puerto Rico, and our own Second Circuit right here in New York, which covers Connecticut, New York, and Vermont, ruled the exact opposite. They struck down the residency requirement in Maine and New York, saying they do violate the Constitution. So now we got a full-blown circuit split. 3 federal courts, 2 completely different answers, and a whole bunch of uncertainty. That's the kind of mess that the Supreme Court was built to clean up. Here's the wild card in case things couldn't get messier. The Trump administration wants to move cannabis from Schedule I to Schedule 3. That might sound like inside baseball, but here's why it matters. The Ninth Circuit's whole argument was built on one idea. So if the feds are calling it Schedule 3, which means they're acknowledging that there's medical value, then suddenly the market does exist, at least in the government's eyes. That undercuts everything the court decided. The Ninth Circuit's decision in these 9 states, California, Washington, Oregon, Arizona, Nevada, and a few others, in those states, they can keep giving preference to local applicants. But here in New York and in Connecticut, the Second Circuit's opposite rule applies. That means our residency preferences are still vulnerable to be struck down. Translation, your rights depend on your zip code. A cannabis business owner in California gets protection that a business owner in New York doesn't. Same industry, same product, completely different rules. That's not justice. That's just a patchwork mess.